Welcome and thank you for joining part one of Seyfarth's micro webinar series, Recent Legislative Developments Affecting Washington, D.C. Employers. This installment of the series will focus on the D.C. Human Rights Act. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature in WebEx. However, if your question is not answered, our presenter will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Samantha Brooks. Sam, you may begin.
Thank you. Good morning or good afternoon, everybody. Thank you so much for joining us today. I'm excited for our presentation, and I hope that you'll find it interesting and informative. So let's get started. Slide, please, Dave. So that is me. Go ahead, Dave. Thank you. So let's first go through the agenda, everybody. The first thing that we're going to talk about is the D.C. Human Rights Act. We'll give a quick overview of the Act and the expanded protections afforded by the recent amendments to the Act. Then we'll move on to the expanded definition of harassment under the Act and some implications for employers in the district. And then we'll briefly discuss some new enforcement mechanisms under the recent amendments to the Act. Next slide, please. So I am sure most of you know that under the D.C. Human Rights Act, all employers in D.C. are prohibited from refusing to hire, terminating, or otherwise discriminating against or harassing any individual with respect to the compensation, terms, conditions, or privileges of employment on the basis of the now 18 protected categories, which we will talk about in a moment. The D.C. Human Rights Act also provides special requirements and protections for pregnancy, childbirth, and related medical conditions, credit information, and victims of domestic violence, sexual offenses, and stalking, also known as DVSOS. And we will talk about those very briefly a bit later on in the presentation. Next slide, please. So first things first, who is a covered employer under the D.C. Human Rights Act? The Act provides that any person for pay or other compensation employs an individual, including any person acting in the interest of such employer, directly or indirectly, and professional associations are a covered employer under the Act. Any person acting in the interest of such employer, think supervisor or supervisors for that piece of the definition of employer. The law, the D.C. Human Rights Act, applies to all employers in the district, regardless of the number of employees. And that is much broader in scope than Title VII of the Civil Rights Act of 1964, for example, which applies to employers with 15 or more employees. And under the D.C. Human Rights Act, individuals can be employers. Next slide, please. So first big change under the Act. Who is a covered employee under the Act? Any individual employed by or seeking employment, i.e. an applicant, from an employer, including unpaid interns and independent contractors. The definition of employee now explicitly includes independent contractors, which means that the protections and prohibitions found in the D.C. Human Rights Act apply to independent contractors and employees alike. It also means that independent contractors can avail themselves to things like filing a charge of discrimination with the Office of Human Rights under the D.C. Human Rights Act. I would suggest that you consider how this change impacts your contracts with independent contractors, if any, whether or not policies and handbooks are distributed to independent contractors, and whether EEO or harassment training is provided to independent contractors in the regular course of the contract relationship. Next slide, please. So the second big change since October are the addition of one more protected trait under the D.C. Human Rights Act. The Act prohibits discrimination and harassment in employment based on 18 protected traits, which is much broader than those than the protected traits under Title VII, which I'll talk about in a moment. But the protected traits under the D.C. Human Rights Act are race, color, religion, national origin, sex, which includes gender, pregnancy, childbirth, related medical conditions, breastfeeding, and reproductive health decisions. Age, which is 18 or older. Note that under the Americans with Disabilities Act, the Age Discrimination in Employment Act, the covered age is 40 and over. The DC Human Rights Act also covers marital status, personal appearance, which includes manner or style of dress and or manner or style of personal grooming, including but limited to hairstyle, facial hair, beards, things like that. Sexual orientation, gender identity or expression, family responsibilities, political affiliation, disability, matriculation, genetic information, credit information, status as a victim or family member of a victim of domestic violence, a sexual offense, or stalking, and as of October, homeless status. So I just want to flag the differences under Title VII very briefly. So age at all, an age of 18, personal appearance, family responsibilities, political affiliation, matriculation status, status as a victim of domestic violence, sexual offense, or stalking, and homeless status are not covered under Title VII. Another example of how the DC Human Rights Act is much broader than Title VII. Next slide, please. So what is homeless status? Homeless is a defined term under the Act, and it is the same definition that can be found in the section of the DC Code that applies to services for homeless individuals. And the full definition is on your slide. It looks like it may have been split into two slides, but the full definition is there really for your reference. But in sum, there are four subparts to the definition of homeless. The first is an individual or family that lacks a fixed, regular, or adequate nighttime residence. Those folks might reside in a public place like a park, a public housing facility, or someone who may be exiting an institution like a prison, jail, et cetera, that doesn't have housing secured after their release from the institution. The second definition of homeless is an individual or family who has lost or will imminently lose their primary nighttime residence, has not secured a subsequent residence, and doesn't have the resources to secure permanent housing. The third definition, next slide, Dave, is an unaccompanied youth who doesn't have housing and may be expected to remain in their unhoused status because of a disability or other circumstances that prevent them from finding housing. And the last sub-definition of homeless is an individual or family fleeing a domestic violence, sexual offense, or stalking related violence or other violence who doesn't have any other residence and lacks the resources to obtain housing. Next slide, please. So I briefly want to talk about the other protections afforded by the DC Human Rights Act. This is more of a reminder or a primer on these unique protections that the Act provides. The first is for pregnancy, childbirth, and related medical conditions. And the Human Rights Act requires employers to treat an employee affected by pregnancy, childbirth, a pregnancy-related or childbirth-related medical condition, breastfeeding, or reproductive health decision, the same for all employment-related purposes as any other employee with a similar ability or inability to work. An employer is required to treat an employee temporarily unable to perform the functions of their job because of a pregnancy-related condition in the same manner it treats other employees with temporary disabilities. And that includes the duty to accommodate that employee. The last thing on this I wanted to flag is that employers are not required to provide insurance coverage, health insurance coverage related to reproductive health decisions. Next slide, please. The next unique protection under the DC Human Rights Act is for victims of domestic violence, sexual offenses, and stalking. And those protections come from the Employment Protections for Victims of Domestic Violence, Sexual Offenses, and Stalking Amendment. Again, the abbreviation is DVSOS, which I might say in the next couple of minutes. Under this Amendment Act, employers may not discriminate against victims of stalking and their family members, including because the employee participated in a criminal, civil, or other proceeding related to DVSOS, the employee sought medical or mental health treatment related to DVSOS, or an individual, caused a disruption or made a threat to your employee's employment or workplace related to DVSOS. And the third option there really envisions the scenario where, for example, an estranged partner shows up at a workplace, makes a scene, makes a threat, et cetera. Employees are required to provide reasonable accommodations to victims of or family members of victims of DVSOS when necessary to ensure that employee security and safety, absent undue hardship. And some examples of those accommodations could be transfer or reassignment, a modified schedule or leave, changing a workstation, phone number, or email address for your employee, installing a lock on an office door, assisting with documenting incidents of DVSOS that occur in the workplace. For example, an estranged partner showing up at the workplace and causing a disruption, or implementing other safety procedures in response to actual or threatened incidents of domestic violence, sexual offenses, or stalking. Lastly, employers may not disclose any information related to an employee's status as a victim of or family member of a victim of DVSOS, and if such a disclosure is made by the employer, it must notify the employee of the disclosure. Next slide. The last protection, special protection that I want to talk about under the DC Human Rights Act is protection for credit information. And the DC Fair Credit and Employment Amendment Act prohibits employers, employment agencies, and labor organizations in the district from discriminating against an employee or applicant based on credit information, which includes credit worthiness, credit standing, credit capacity, or credit history, even if an applicant or employee voluntarily discloses this information. So employers, unless excluded by law, which I'll talk about in a moment, may not directly or indirectly ask for or rely on credit information of an employee or applicant in making any employment decision. So this prohibition does not apply in 7 specific situations. Where DC law requires an employer to obtain an employee's credit information, where an individual applies for or is employed in a position with a law enforcement function, police, special police, et cetera, where credit information must be provided to the Office of the Chief Financial Officer of the district, where an employee must have a security clearance under DC law, where DC government employees have to provide certain disclosures to BEGA, the Board of Ethics and Government Accountability, or to the Office of the Inspector General, the OIG, where the job or position would require the employee to access personal financial information. For example, when an employee is employed by a financial institution, a bank, et cetera, or where an employer is following a lawful court order or cooperating with a law enforcement investigation. Next slide, please. So the third big change in the recent amendments to the Act is the expansion really, in the definition of harassment. The Human Rights Act prohibits harassment on the basis of the 18 protected categories that we just discussed a moment ago. Everything from race to sex to matriculation status to political affiliation to homeless status. The definition of harassment in the Act is quite broad. It is defined as conduct, whether direct or indirect, verbal or nonverbal, that unreasonably alters an individual's terms, conditions, or privileges of employment, or has the purpose or effect of creating an intimidating, hostile, or offensive work environment. And I just want to break down direct versus indirect conduct, verbal versus nonverbal conduct. So direct conduct, for example, is a comment made to an employee, or for example, a slur written on the employee's door, in their cubicle, etc. Indirect conduct would be things like a comment overheard by an employee that wasn't necessarily directed to them, or a slur, for example, written on a bathroom stall in a public space that every employee has access to. Verbal conduct is exactly what it sounds like, spoken words. Nonverbal conduct could be any number of things. It could be hand gestures, objects like, for example, a noose, which we have all seen in the news as a particularly egregious example of race-based harassment, or posters put in the workplace, somebody's private office that may have language or images offensive to an employee. Sexual harassment is specifically incorporated in the definition of harassment in the Act. And sexual harassment means any conduct of a sexual nature that constitutes harassment under the definition in the Act. And sexual advances, requests for sexual favors, or other conduct of a sexual nature where submission to the conduct is made either explicitly or implicitly a term or condition of employment, or where submission to or rejection of the conduct is used as a basis for an employment decision affecting the individual's employment. Next slide, please. The amendments to the Act, put into effect a new harassment standard, which is the, quote, totality of the circumstances standard. Historically, DC applied the severe or pervasive standard when evaluating harassment claims under the DC Human Rights Act. And the severe or pervasive standard still applies in most jurisdictions and is still the standard under Title VII of the Civil Rights Act of 1964. When evaluating evaluating whether conduct is severe or pervasive, courts generally look to a pattern of conduct in the workplace that is either severe or pervasive. Now, the standard under the DC Human Rights Act is the totality of the circumstances. Significantly, the Act explicitly provides that harassment under the DC Human Rights Act need not be severe or pervasive to constitute harassment, and no specific number of incidents or specific level of egregiousness is required. That language is in direct contrast to the requirement under Title VII that to be actionable harassment, the conduct complained of must be severe or pervasive. And the Act now explicitly provides that no specific number of incidents is required, opening the door for a single incident to be sufficient under the DC Human Rights Act to state an actionable claim for harassment. Next slide, please. The Act identifies 5 factors to determine whether conduct constitutes unlawful harassment under the DC Human Rights Act. And those factors are the frequency and duration of the conduct, the location where the conduct occurred, whether the conduct involved slurs, epithets, stereotypes, or humiliating or degrading conduct, and whether a party to the conduct held a position of formal authority or informal power relative to another party, i.e., whether one party was a supervisor to the other party. Next slide, please. The Act also now specifically says that conduct may constitute unlawful harassment regardless of the following circumstances. So a single incident, a single example of conduct may be sufficient to constitute harassment. The fact that the conduct was directed toward a person other than the complainant, that indirect example we talked about a moment ago, may be sufficient for a claim of harassment. The fact that the complainant submitted to or participated in the conduct won't preclude a claim. So think of a situation where a complainant laughs off the comments or engages with the perpetrator or bad actor, if you will, when they make a joke that the complainant might find offensive. That will not preclude that complainant from making a claim. It will not matter whether or not the claimant was able to complete their employment responsibilities despite the conduct. It similarly won't matter if the conduct didn't cause a physical or psychological injury. It similarly will not matter if the conduct occurred outside of the workplace, which is something new for employers to jive with, which we'll talk about also in a moment. It also may not matter if the conduct was not overtly directed toward a protected characteristic. Next slide, please. So what? We have these new changes to the definition of harassment. What does that mean for you and your business? The first is the potential for employees to prevail on claims under the DC Human Rights Act that might be dismissed under the severe or pervasive standard. In other words, an employee may be successful on a claim under the DC Human Rights Act for harassment, but unsuccessful on a claim under Title VII for harassment. There is also the potential for employees to prevail in instances where alleged misconduct was less frequent or egregious. So again, an employee may be able to be successful on a single incident under the DC Human Rights Act, but it is less likely that they will be successful under Title VII with a single incident of conduct. The other takeaway is now it is quite clear that even interactions with colleagues after work or on weekends could be the subject of harassment complaints. So think about the situation where a group of colleagues go out after work to a bar, or go out on the weekend to a museum or a play or a barbecue or what have you, and one employee says something or does something that the other employee finds offensive. Employers are now going to have to face claims that they are on the hook for those types of off-duty behavior. Overall, this is really a fundamental change in how employers have come to understand and recognize harassment cases. So in terms of next steps, what can you do? Perhaps consider reviewing anti-harassment policies and harassment training that you give to your employees to see how you might adjust those trainings to deal with these new provisions under the DC Human Rights Act. Next slide, please. So the last thing that I want to talk about are a new enforcement mechanism under the Act. So in effect right now, pursuant to temporary legislation, is a provision of the DC Human Rights Act that clarifies the authority of the Office of the Attorney General, the OAG, to bring civil action under the Act in the name of the District of Columbia for violations of the Act. It also provides the OAG with investigative and enforcement tools. In a civil action, the OAG may obtain injunctive relief, civil penalties, hiring and reinstatement of employees, restoration of membership to labor organizations, et cetera, the extension of unsegregated equal accommodations, facilities, and privileges to all employees, compensatory damages, reasonable attorney's fees, et cetera. And this relief is much the same as what the Office of Human Rights can recover and what a plaintiff could recover in a civil action under against an employer. But now the OAG is explicitly empowered to seek that relief. Next slide, please. Under this legislation, the OAG may seek subpoenas for the production of documents or materials and testimony of witnesses before commencing suit to determine whether or not to sue. In other words, they now have investigative powers, much like the Office of Human Rights already has to investigate charges brought before it. Those investigative powers, though, that the OAG now has include to subpoena witnesses, administer oaths, examine individuals under oath, require sworn answers to interrogatories, and compel the production of documents. So the last thing I really want to say about these enforcement powers is the section that provides for enforcement by the OAG was enacted pursuant to temporary legislation, as I mentioned a moment ago, the genesis of which was COVID-19 related legislation, which essentially provided the OAG enforcement mechanisms, much like those we see in consumer protection matters, for example. Since the early part of the COVID-19 pandemic, there has been a series of other temporary legislation that kept this temporary provision enforced throughout the last couple of years, through the present and through the end of this year. This past week, permanent legislation went into effect that speaks to further expansion of OAG rights to investigate and seek remedies under the Act. The permanent legislation certainly expands the OAG powers beyond the temporary legislation, both in terms of timing, in other words, beyond the temporary time period, and also in terms of using investigative tools to enforce the DC Human Rights Act Again, more like what we see in consumer protection statutes, consumer protection lawsuits brought by the Attorney General. We do expect some continued enforcement from the OAG in terms of the DC Human Rights Act, but it remains to be seen whether that focus will be in the employment context. We have already seen the Attorney General's focus exclusively, not quite exclusively, but significantly on the housing arena. And the OAG has been very clear that housing is a priority for it. And as a result, we do expect that housing will be the focus of the OAG's new powers, but it remains to be seen what the OAG will do with its new powers, if you will. And we, Seyfarth, will certainly push out more updates when we get more clarification on those issues. Next slide, please. So I will read the CLE code now. The CLE code is SS, like Seyfarth, Shaw, 7958. SS 7958. And with our last couple of minutes, I'm going to take a look at the questions. It does not look like there are any questions. So in our last couple of minutes, if anyone would like to ask a question, I'd be happy to try to answer it. If not, you can always follow up with me by email, and I would be happy to assist in any way that I can.